A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
My bitch a choosing lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes get the most, not the lesser. Trash like the fuck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm pulling business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side. If you know what I mean, I show you shit you never seen. The 7 wonders of the world. And I can make you the 8th if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker, walk a green mile. Piling up the paper on the dining room table, cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian label, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man, they need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get toes.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Hey, what's going on, y'all? How you doing this evening? Hope you had a fantastic week. Hopefully, the stream is running better, and we'll be able to watch this successfully. Anyway, so yes, enjoy my sweater. So tonight we are going to be doing a part 1 of a new series detailing Mr. Kim Blandino. This guy is he's kind of a piece of work. There's no other way of saying it. Hello to all of you. I'm going to say hi to all of you and not every single person specifically because we're going to be here all night. I mean, it's a product of a lot of the support that I'm getting from you guys. Anyway, so the first thing is, I think, last week is when I first discovered this guy. Law Talk with Mike has been covering him for like the last couple of weeks at least. And the first thing that I'm going to reiterate what I said before, and I'll say it again now. He's not a sovereign citizen, and I said that the first time I was watching, and after going down the full rabbit hole, I maintained that he's not a sovereign citizen. But he is a special kind of litigant. So, and yeah, I did actually get to watch most of that interview that Mike had with Mr. Blandino last week, which is pretty awesome. But what we're gonna do is we're gonna start from the beginning, and what I mean by that, we're gonna start from Mr. Blandino's history, and I think doing that will paint a better picture of how he operates, how he's operating now, and from what we've been able to see so far. So the first thing we're going to be doing is read to you this court case. It's actually from the Nevada's the U.S. Bankruptcy Court for the District of Nevada. And the reason why I'm gonna read this to you, and yes, it's gonna be reading. It's gonna be boring, but I think honestly it's important to read the factual background here. I'm not gonna read the whole case, but I want to go. The opinion goes through the factual background surrounding Kim and his family history. And then we're going to showcase some of the earliest videos we've seen online, and then we're going to move forward in the timeline to the current day. So, this is a bankruptcy court where Blandino, well, you know what? I'm just gonna go ahead and read it because the judge is gonna be reading it because he's gonna explain why we're starting out with a bankruptcy case in 2004. So let's go. Oh, where's the actual opinion? Okay. The trial in this adversary proceeding took place on April 19th through the 20th, 2004. The plaintiff, Kim Blandino, represented himself. The debtors, defendants, Nancy and Michael Bradshaw, also represented themselves. After consideration of the testimony, exhibits, applicable law, and arguments, the court now rules. Well, you know what? I'm going to go straight into it. Jurisdiction, the issues at play, factual background. Debtor Nancy Bradshaw and plaintiff Kim Blandino were married in 1987. The reason for the air quotes is that they never actually got a marriage license. So under the state law of Nevada, they weren't actually married in the eyes of the state. As a result of this union, 2 sons. This is bankruptcy. And yeah, this is bankruptcy court. As a result of this union, 2 sons were born. Zachary was born May 17, 1988, and Andrew was born June 16, 1990. The reason why we have their names is that right as of this filing, they were already in the age of majority. In approximately February 1991, the couple separated. On July 1st, 1991, Nancy petitioned the Nevada State Court to award her primary physical care, custody, and control of Zach and Andrew. Although an order to that effect was not introduced into evidence, there is no dispute that the boys have legally resided and remained with Nancy since that date. From the time they were separated in 1991 until June 6, 1992, Kim and Nancy worked out a periodic visitation schedule. Part B. The abduction. However, on June 6, 1992, Kim, without explanation or warning, abducted and kidnapped the 2 boys. Distraught, Nancy contacted various law enforcement agencies for assistance in locating her children, then ages 4 and 2. She also appeared on television in order to publicize her plight and pled with the public to assist her in locating your children. Although Kim changed his identity, he was cited in Portland and eventually apprehended with the children in Phoenix, Arizona on or about January 25th, 1993. In all, Kim's disappearance, boys in tow, lasted 7.5 months. At the time of his arrest, the boys were taken away in a police car and placed in protective custody. The children's trauma had been exacerbated by Kim telling them that their mother was dead and that she had, quote, spiritual cancer. During this period, Nancy had no communication whatsoever with either Kim or the boys. Kim was eventually convicted of kidnapping on July 19th, 1994, at which time he was immediately sentenced to prison where he remained until May 27th, 1998. So he spent about 4 years in prison. During the interval between his arrest and conviction, beginning May 30th, 1993, Kim was allowed some supervised visitation with the boys. While there was slow progress towards healing made, the supervising caseworker was reluctant to allow more informal visitation since Kim refused to provide her with any details on where he worked or lived, with whom he associated, or the fundamentals of his beliefs, citing his Fourth Amendment rights. Thus, because the caseworker, quote, did not know the content or boundaries of his belief system, end quote, she kept a tight rein on the supervised visitation during the period between his arrest and incarceration. Kim was sentenced to prison and began serving his term for kidnapping on July 19, 1994. Until his release in May 1998, Kim's contact with the boys was sparse, limited to occasional phone calls, a few letters, and one visit before his release. Kim was released from custody on May 27th, 1998. Visitation. Upon his release, court-supervised visitation began again. The Domestic Relations Court, appointed by Alton J. Cathay, I'm pretty sure I butchered that last name, to assist in that, a family therapist to assist in that regard. The purpose of Mr. Cathay's involvement was to assist. Oh, you know, I'm gonna just get Kathy. The involvement was to assist in the reunification process. Mr. Cathy met with the parties and the boys from June 1st to July 22nd, 1998. A meeting was scheduled for August 19th. 1998 was canceled by Nancy. Ultimately, Mr. Cathy's report concluded that reunification is not in the best interest of the children at this time, because although he felt that both parents loved the children, Kim's approach to parenting was unconventional in that, quote, he conducts his life by his interpretation of the laws of man and God without regard to the expectations of society in which he lives, end quote. See, they're kind of, that does kind of sound a little sovereign citizen-y. But let's continue. Mr. Cathy then resigned from the case. There was no significant contact with between the parties and no visitation activity of any note for approximately 2 years until visitation resumed in approximately May 1999. On August 2nd, 1999, Kim engaged the services of Dr. Louis F. Mortillaro, PhD, to review the history of the case and especially Mr. Cathy's report. In an affidavit on August 2nd, 1999, Dr. Mortillaro opined that Mr. Cathy had considered, quote, his personal values, end quote, over rational psychological reasons. Dr. Mortillaro endorsed another effort at reunification. On August 12th, 1999, Kim filed an emergency motion for reunification, attaching the Mortillaro affidavit and seeking renewed visitation. A hearing was set in September 9th, 1999. Although the court's order was not admitted into evidence, the court apparently agreed with Kim and appointed Dr. Gary Lenkit to assist in reunification efforts. The process of interviews and psychological testing began anew. By October 2nd, 2000, Dr. Lenkit appeared hopeful that visitation in a less restrictive environment might, in time, be achieved. From October 2000 through the end of September 2001, matters concerning visitation and counseling were apparently succeeding. Kim's visits with the boys became more regular, and the strictures of the environment loosened from being held entirely at a psychologist's office to being held at parks, bowling alleys, and other normal outside venues. Now we go to section F. It's so far so good, right? It sounds like, you know, they're moving. It sounds like there's progress being made. But here's where you know, it all falls apart. On approximately August 10th, 2001, Nancy revealed to Kim that she intended to relocate to South Carolina with her family. Kim was distraught at the idea of having his boys so far away, and on August 12th, 2001, wrote Nancy that he would also consider a move to South Carolina. Both parties recognized that court permission was necessary, and Nancy had filed a motion with the family court on July 17th, 2001. Seeking permission to relocate. By September 5th, Nancy's motion to relocate was on file, and Kim wrote to her attorney that he would oppose it. Apparently, Nancy's decision... So basically, y'all haven't even been paying attention to me, and you're just ripping into my sweater. Like, should I just not even bother with a stream anymore? I thought it would be funny, but apparently I'm the butt of the joke. So, whatever. Should I fucking change my shirt? Or what? Anyway. Jesus. Anyway. Already lost my train of thought. Apparently Nancy's decision was causing friction between Kim and Nancy. And Nancy took the position that that Kim cannot see the kids unless Kim scheduled a meeting about moving with Dr. Lenkit. Dr. Lenkit, by that time, had supervised the visitation and reunification effort for over 1 year. During the same period, Kim began... During this same period... yeah, you know, I know you were joking, Andrew, but you know, I was paying attention to chat, and I was seeing the back and forth between some of y'all. So y'all were kind of patting on to it, but whatever. Moving on. We're moving on. During the same period, I'll get to the super chats later. During the same period, Kim began proceedings in the family court to recuse certain judges and appoint others. So this started in 2000. So at this point, he's already started to try and recuse judges and appoint new ones in the family court system during this. This chain of events paralleled the disintegration period and led to natural delays due to administrative problems with finding multiple judges for the domestic case. On by August 30th, 2001, the Nevada Supreme Court issued an administrative order stating that all judges within the family court division have disqualified themselves. The Nevada Supreme Court then appointed a visiting judge, Judge Papez, from outside the county to preside over the case. Not satisfied with the Supreme Court's choice of judge, Kim filed a motion on September 11, 2001, asking the court to stay the proceedings pending his efforts before the Supreme Court to obtain a different judge. Pattern, right? Seems to be a pattern here. Thus, by mid-September 2001, Kim had caused all of the family court judges in Clark County, Nevada, to universally recuse or be disqualified. At the same time, Nancy was moving ahead on her plan to relocate to South Carolina. She and her new husband, Michael Bradshaw, had listed their house for sale, had it in escrow, and were scheduled to close on or about September 21, 2001. Nancy, Kim, and Mike continued to discuss ways of dealing with Kim's visitation rights after the move to South Carolina, but Kim vehemently opposed the move. At a meeting at Nancy's and Michael's home on September 7, 2001, an impasse was reached. During a heated discussion manipulated by Kim, Kim intentionally crossed the line and began advising Michael, the new husband, about how Michael should raise his own daughters. And then, in parentheses, this is in the opinion, in parentheses, this from a man who had kidnapped his own children and served 4 years in prison for such a crime. End quote. Michael testified that Kim called him a, quote, bad dad, end quote, and stated that if Nancy and Mike moved to South Carolina, that, quote, I'll have to take care of your girls for you, end quote. Michael, provoked, stated, quote, don't talk about my daughters again, or I will kick your ass. Mention my daughters again, and I will kick your ass, end quote. Kim was then told to leave, and he did. No physical contact of any kind occurred. There was no evidence that Michael made any threatening gesture towards Michael. I think that's a typo. That's supposed to be Kim. That Michael made any threatening gesture towards Kim. During this difficult period, Nancy was pleading for the intervention of Dr. Lenkit, the court-appointed psychologist. I know, right? On September 18, 2001, Kim filed a state court civil action against Nancy and Michael in Clark County Nevada. The overriding purpose for the litigation was to, quote, to reestablish a bonded relationship with Zachary and Andrew Blandino. The essence of the complaint is found in count 2 thereof, wherein Kim contested Nancy's decision to relocate in South Carolina. Count 1 of the complaint details the events leading up to the words Kim had with Michael on September 7th, which Kim contended created a legal cause of action, presumably the tort of assault. Knowing that the home, and here where we get to the reason why we're in we're getting into a bankruptcy issue. Knowing that the home was in escrow and set to close on or about September 21st, 2001, and knowing that knowing further that all of the judges of the family court had been disqualified or recused in the domestic case, Kim took a desperate legal step in his plan to prevent Nancy's move. He filed a lis pendens against Nancy's and Michael's home. That singular event thereby caused the sale of the debtor's home to collapse 3 days shy of closing. Nancy and Michael had, at the time, leased business property and a personal residence in South Carolina and had placed deposits thereon. They had given notice at their jobs. They had also been packing all of their belongings in preparation for the move. Kim's filing of the lis pendens created a major disruption to their plans, and he injured them economically and emotionally in so doing. Now they had before them the task of unwinding their affairs and unpacking. At trial, Kim defiantly maintained his stance was proper without citing specific authority, and cavalierly maintained that the debtors could have, quote, bonded over, end quote, the lis pendens. He put on no evidence, however, that Nancy and Michael had the resources to do so. Kim's testimony at trial belies his statement that he thought he was filing the correct legal documents. At trial, Kim stated that he filed the lis pendens to, quote, stop the sale because, quote, the family court was not fast enough. So he gave it away that he filed this lis pendens in bad faith. Kim's September 18, 2001 lawsuit did not state a single fact which concerned or related to the land upon which he had placed the lis pendens. Nancy and Michael answered the complaint. So just for y'all's sake, a lis pendens is a notice that is filed with a county clerk's office, a county recorder's office, wherein you are stating that a property is about to be the subject of a lawsuit. And it effectively does almost the same thing as a lien, putting a lien on it. It's not the same thing, but it effectively does the same thing in terms of obliterating a potential sale on the house. Because no buyer is going to want to buy a property if there's a lis pendens, meaning that whoever files the lis pendens would have a higher claim to the property than even the buyer would. So it basically fucked over Nancy and Michael's sale of their home. And probably ruined them. Well, it kind of did ruin them, as well. We're going to find out. So, on September 24, 2001, the final meeting was held at the office of Dr. Gary Lenkett. All parties were present. After discussing the current state of affairs with all parties, Dr. Lenkett detailed Kim's lack of cooperation and his creation of the tremendous conflict now confronting the parties. He urged the court to continue supervised visitation and described Kim's comments at the session to be, quote, particularly disturbing, end quote. Dr. Lenkett noted, during our session on September 24th, I found two of Mr. Blandino's statements to be particularly disturbing. He referred to his kidnapping of his children as, quote, seeking self-help, end quote. Additionally, he stated that Ms. Bradshaw was the cause of his placement in prison. Obviously, his version of his kidnapping and incarceration is at odds with reality. He appears quite unable to assume responsibility for his behavior. During the approximately 1 year that I have worked on this case, progress has been made in the relationship between Mr. Blandino and his children. However, his recent actions have caused a setback in these relationships. Mr. Blandino appears to be placing his perception of his legal rights before the best interests of his children. Dr. Lenkit, calling the situation now intractable, resigned. Importantly, Dr. Lincoln stated that, quote, therefore, since I will not be available to monitor the situation, all visitation will need to be suspended at this time, end quote. Visitation came to a halt as a result. On October 1st, 2001, Kim filed an emergency motion for immediate continuation of visitation after disruption by debtors. In it, Kim recounted the numerous family court judges who have been assigned to the 9-year proceedings, and on page 6 described his unhappiness with visiting Judge Papez, who, if you recall, was the one who was appointed by the Nevada Supreme Court after all the other family court judges had recused or removed themselves from the proceedings in the county. Kim related in his motion that he filed a motion to stay proceedings with Judge Papez. Kim was referring to his latest efforts before the Nevada Supreme Court to remove Judge Papez and have once recused Clark County Judge T. Arthur Ritchie again assigned to the case. This proceeding was in the nature of a mandamus action. Because the mandamus request was pending, the family court acted to stay all further proceedings involving the kids' disputes. This order was entered upon Kim's request. The credal portion of the order, I'm not even sure how to pronounce that. I haven't seen that one. Of the order stated, it is hereby ordered that all proceedings in this matter are stayed pending the Nevada court's review of the defendant Kim Blandino's petition for writ of mandamus. Although the courts had halted all proceedings and actions in the family court area, either pursuant to Kim's request or as a natural consequences of Kim's legal maneuvering, Kim nonetheless maintained in communications with Nancy and others that everything regarding his visitation rights should be as they were before. No. The reason why I say no is because he started this. What's the old saying? You can't put the toothpaste back in the tube. You know, you started this this train. It ain't stop. You can't just stop it or have it come to a brief stop because you didn't realize that your actions was going to cause this create this consequence. On December 17th, the Nevada Supreme Court granted Kim's mandamus request and ordered Judge Ritchie to once more preside over the domestic case. Judge Ritchie heard Kim's motion to restart the visitation on February 5th, 2002. The court noted that reunification will be explored, but ordered that there would be a further hearing to determine the conditions of any future visitation. The court record is clear as to what the judge ordered on that date, February 11th. He ordered that the parties consult with a court-appointed psychologist. He also ordered that this would be done in order to assist the court prior to making a judicial decision in this matter. The court did not make any orders regarding visitation, nor did he order the reinstatement of visitation at that time. The judge also ordered that Kim be responsible for 100% of Dr. Velasquez's costs. However, Dr. Velasquez declined to accept the case on March 4th, 2002, which honestly I don't blame them. Kim continued his letter writing campaign to Nancy, and without the benefit of any documentation or experts, advised her that he calculated his damages for being unable to see his boys at $5,000 per day. Another sign of a little bit of sovereign citizen tactics. Nancy, for her part, continued to obey the court orders to suspend a visitation. She also ignored Kim's letters. And note that on number 8, by this time, Nancy had decided to withdraw her petition to relocate to South Carolina. So, yeah, Kim's Liz pendens basically nuked his ex-wife's plans. On May 1st, 2002, Judge Ritchie finally entered an order reinstating Kim's visitation on a supervised basis at a locale called Donna's Place. The judge then set a follow-up hearing on June 3rd. On May 23rd, 2002, Donna's House executive director sent an evaluation report to the court. It noted that, among other things, that Kim, quote, has been calling and harassing staff regarding getting a copy of his court report, stating he feels he is entitled to it since he is acting as his own attorney, end quote. Another, well, again, pattern seeking. Visitation. The exhibits received in evidence reflect that after Donna's House began handling renewed supervision, matters progressed satisfactorily and contact between Kim and his boys improved. Periodically, the court would conduct status hearings and would receive progress reports from Donna's House. As time went on, the court periodically adjusted and liberalized the visitation schedule. Finally, at a hearing on December 2nd, 2002, the court relaxed the supervised visitation, finally allowing Kim to see the boys on an unsupervised basis. Nonetheless, the court defined the contact and the visitation with clarity and specificity. Testimony of the parties at this hearing before the bankruptcy court revealed that Kim and Nancy now attempt to work together to modify the visitation schedule as circumstances dictate. However, periodically, a disruption in visitation flares up, whereupon Kim will quickly voice his legal rights to Nancy and threaten to take her back to court. In general, however, visitation regained a sense of semblance of order and remains so to the present day. On January 29th, 2004, upon Kim's motion, Judge Ritchie granted Kim joint legal custody of Zach and Andrew, provided that the previous visitation schedules ordered by the court shall stand. And now we get to why we're here in bankruptcy court. Sorry. Lurking in the background throughout the fall of 2001 and spring of 2002 was Kim's lawsuit against Nancy and Michael and its attendant and brooding Liz Pendens. As noted above, the lawsuit was filed by Kim in reaction to Nancy's decision to relocate to South Carolina and the de minimis event of Michael's statement, which Kim provoked by telling Michael how Michael should parent his own children. Not want to leave any perceived wrong lying fallow. I love the judge's sarcasm. Kim found a new and additional target, Dr. Gary Lenkit. So the previous psychologist. On March 25th, Kim amended his state court lawsuit to add Dr. Lenkit, accusing him of being in some sort of vague conspiratorial relationship with Nancy and Michael to deprive him of his visitation rights. Oh, God. Kim couched his amended complaint in terms of conspiracy, emotional distress, and its intentional infliction. Additionally, Dr. Lenkit was accused of some ill-defined and unspecific fraud. Nancy and Michael failed to answer the amended complaint. And Kim entered their default. Kim testified that he then asked the county clerk to award him a judgment for a higher sum, but that individual in the clerk's office said she only felt comfortable entering $50,000. There is no evidence presented to this court that Kim provided any verification for this amount, nor offered any credible evidence or any testimony to the clerk. Thus, on May 8th, 2002, Kim had a judgment against Nancy Bradshaw for only $50,000. The judgment is silent as to Michael, as to the marital community. As to the marital community. On August 16th, the court also found that Dr. Lenkit had dismissed dismissed Kim's lawsuit against him. On August 16, 2002, Nancy and Michael filed a Chapter 7 bankruptcy petition to this court. Among their assets, they listed their home with a fair market value of $150,000 and a mortgage lien of $115,000. They claimed a homestead exemption thereon of $34,715. Kim was listed as an unsecured creditor with a $20,000 claim. Total unsecured claims amounted to 81,910. Other than the instant advisory proceeding, no other creditor has challenged the debtor's bankruptcy or their right to a discharge. The trustee has determined that the debtor's case is of the no asset variety, and the debtors were granted a discharge on March 9, 2004. Among the pleadings in both this action and in the administrative case is a motion for a stay relief filed by Kim to allow him to continue to pursue collection of the state court judgment against Nancy. Basically, what he's saying is that the bankruptcy court allowed them to discharge their debt, so wipe it clean because there's no assets. They have nothing to provide. But Kim, being Kim, he wants his money. So he filed a motion to stay to try and get his money, his piece of the pie. Because of the outcome of this matter, that motion will be denied as moot. And as the debt represented by the $50,000 judgment is now discharged. So, GG. On November 25th, 2002, Kim filed this non-dischargeability action joined with a motion for stay relief, as well as a request for an injunctive relief as to his ongoing visitation rights. An answer was eventually filed on April 18th. A trial on all of these issues was held on April 19th, 2004. 19th through 20th, 2004. In a pretrial motion, Kim had attempted to subpoena Dr. Gary Linkett for trial. This court quashed the subpoena, finding Dr. Linkett not to be a material witness. Now that the court in this matter has concluded, that opinion was reinforced. Dr. Linkett was not present in the Bradshaw home on September 7, 2001, when the alleged offending words were spoken. Moreover, his report of September 25th contains no actionable conduct on his part. He merely reiterated the outcome of a joint meeting and reported his conclusions to the parties as a court-appointed professional. The comments made by him, taken in context, revealed that he was attempting to carry out his assigned duties to the best of his abilities. He thus could present no relevant evidence on either the Section 523 or the Section 727 issues before the court. So we're not going to go through the rest of it. Ultimately, the judge is like, "Get the fuck out of here. Your request is denied." But the main bit was to go through the factual background of who this guy is and why we're here in the first place. So, ultimately, here's the order. It is ordered that the plaintiff's complaint is dismissed with prejudice. The motion for stay relief contained in count 7 is denied with prejudice. It is further ordered that the list pendens filed against the debtor's real property is hereby quashed and declared to be null and void. It is further ordered that the debtors, Michael and Nancy Bradshaw, are entitled to discharge the debts or debts owing to the plaintiff, Kim Blandino, and are entitled to the benefits of the permanent injunction of 11 U.S.C. 524. It is further ordered that the plaintiff shall file no post-judgment motions of any kind, including but not limited to a motion to reconsider or a motion to alter or amend pursuant to Bankruptcy Rule 9023. So, yeah, he lost outright. Now I feel like you guys have a better picture of who Mr. Blandino is as we get to look at this guy's video history. And I have more court cases that we can that we'll be able to take a look at as we go along. I want to make sure I got this on the right order.
Eric Kosel versus
I apologize. 1 second, y'all.
State of Nevada.
Why is it not playing? How come you guys can't see this? Hang on. What the hell? I may have to go to YouTube for this.
How was
536.
All right, fine. All right, I'll just go to the YouTube playlist that I have. 1 second.
Eric Coastal.
Stop. All right.
Versus State of Nevada.
One second, we're gonna skip ahead to the relevant part. Now, to note that this takes place on July 22nd, 2015. So we are about, 10 years after the 10 or 11 years after the whole bankruptcy fiasco.
effect of his ostensible appeal?
I'm not entirely sure as to standing is
And it's able to handle the evidence. Anything else come out within a week?
Number C-15-305564. Autumn Cameron versus City of Las Vegas.
All right, hold on.
Carly Halpern on behalf of the City of Las Vegas, Your Honor.
I think I might be the wrong table, but Anthony Goldstein, Your Honor, I'm standing in for David Brown today on behalf of Ms. Taylor.
Okay.
Counsel's advised that he's obtained the transcript. I don't have a copy of it. I don't believe that it's been filed.
And that's correct, Your Honor. Mr. Brown, I'm appearing on his behalf. He has the transcripts, and I appeared here today to request time to file the appellate brief, though I understand there's some issues about the timing of obtaining the transcripts.
All right. Well, there's no motion that's been filed that I know of.
No, Your Honor. I have no objection to setting briefings.
Okay. Well, then we'll go ahead and just set a briefing schedule based upon that. And how much time do you need to file your opening brief?
If possible, Your Honor, 45 or 60 days, please.
Ms. Albert, your thoughts on that?
60 days is sufficient.
All right, 60 days will be.
60 days is number 18.
We're still going through the irrelevant bits. I'm sorry.
For me, thank you.
Oh, my God.
But to note, Blandino is in the background in the gallery. I assume that's why he's in this playlist anyway. All right, here we go. Finally.
Versus Henderson Municipal Court. 05849 Lawrence Sparks versus Henderson Municipal Court.
Morning, Judge Erica Gold on behalf of the City of Henderson, or number 8574.
Okay. And who else is here?
Lawrence Sparks. I'm not sure without the defendant.
You can just have a seat right there, Mr. Sparks. Mr. Blandino, what are you doing?
I'm just here to take notes and if he has any you know, anything that needs to be taken down, I can take it down. I'm not here to represent him or in any way pretend that I'm a lawyer or licensed member of the bar.
Okay, I think that it would be better for you to stay in the back of the courtroom. And I don't want you to sit at the counsel table for a case that's not yours if you don't have a law license. So I'm going to ask you to go ahead and just stay in the back of the
For the
courtroom.
record, you've done it in other cases, you've allowed it. In his case, where he was sitting table for the...
I'm just telling you what I'd like for you to do, and
I'll do that.
I expect you to do that, okay?
I object. So, when I first saw these early group of cases, I want to say that, I just thought, he's a busybody, interloper, like he's just a guy who's some random, you know, wannabe lawyer that wants to interject himself into a court case just for the kicks out of it. I had no idea about his history at that time.
All right, Mr. Sparks, go and have a seat. In this case, the note is transcripts not filed. Looks like really what we're trying to do is just figure out some timing for the transcripts being assembled and given over to the City of Henderson and to the court. So, Mr. Sparks, are you aware of that process, that procedure?
Yes, I am. I am familiar with it.
Okay, so let me
I
ask
know
you.
that they haven't, the state hasn't fulfilled their end of the bargain on that, and
Well, let me ask you a question. How long would it take you to gather up the transcripts and provide them to the City of Henderson and to the court?
it's not for me to do that. It's not in the statute.
Okay, well, I think it is.
Only if I lose.
Yeah. Well, let's see what the counsel for the city has to say. Maybe there's something about this that is not in my notes here.
Judge, the city agrees with the court that obviously Mr. Sparks is the appellant. It is an obligation on the transcript. City has concerns that notice of appeal was filed back in April and transcripts have not been filed.
Okay.
Based on that, city is going to make the dismiss the appeals thing.
All right. If you want to file a motion to dismiss, you're welcome to, but I'd like for you to do that in writing and file it and serve it upon Mr.
Right now, if you're unaware, right now this guy is trying to appeal a traffic case. He was convicted, and he's trying to appeal, but he doesn't want to front the money for the transcripts. And in the state of Nevada, according to the court rules, the person who wants to file the appeal incurs the cost of the transcripts in order to provide to the other party.
Mr. Sparks here, and that
he
way
doesn't
has
want
an
to do that.
opportunity to weigh in on it more formally.
Understood?
But Mr. Sparks, what I want to do is set a time to check and see what does happen regarding the transcripts. The thing about it is, as the judge, I really shouldn't give you legal advice. But, you know, when people come into this court and they don't have a lawyer, I tend to want to give them some advice anyway, just procedural advice having to do with the process. I just think it's a fair way to conduct business when people come into a court without a lawyer. And so I don't know what the conviction was. What was the conviction?
Traffic driver.
Okay. So the transcripts of the proceeding where apparently you were found guilty of some sort of traffic violation, in my view, those are your responsibility to provide them to the City of Henderson and to the court, and then we come back and we set a further court schedule. But that's the first step. You've got to get the transcripts. That's the best I can tell you. You may disagree with that, and that's your prerogative, but I'm just telling you that it seems to me that you've got to get those transcripts put together. And so what I'm going to do is set this as a status check regarding what Mr. Sparks does do on transcripts, just a status check to see what happens, and that'll be in 30 days. What's the 30-day return date?
August 19th at 10 a.m.
May I just have some clarification for housekeeping matters? He's filed a couple motions, documents, legal pleadings.
Oh, has he? Did he file them, or did he get some outside help? Something to think about as we go along. Because there are several videos involving Kim that happened throughout this day, July 22nd, 2015. That's why I'm allowing this to continue forward, even though Kim himself isn't at the desk and speaking.
Since the last court date,
Uh-huh.
can the city ask that those not be responded to at this point, and obviously see if we're gonna just have a briefing schedule and he can incorporate those into his initial brief, if we get to that point.
Well, actually, why don't we just do everything on that 30-day date?
Okay, so
In other
let's
words,
see
if
your those.
here's my thought, if he's filed some motions, I don't have them here with me today, but go ahead and respond to them. And we'll set the hearing date regarding any of that activity as well for the same day as the status check on transcripts. And that could be a day too, if you file a motion where I'll deal with your motion.
Okay.
So that's going to be a potentially faithful day here in this case. What's that date again?
It's August 19th at 10 a.m.
All right, so August 19th at 10 a.m., I'll handle the motions that Mr. Sparks has filed. We'll check on the transcript situation. And then if the city of Henderson files something, we'll deal with that day too. Okay? All right, what's next?
Those motions, Judge, for Mr. Sparks, have not been set on calendar because they were not set, or they weren't filed with a notice of motion, so I'll set them on calendar.
Okay, yeah, we'll just do them on that day, okay?
Okay. Next, we're gonna go to page 20. And that's case number C-14-302515, Kim Blandino versus City of Las Vegas.
And now we get to Kim Blandino's own case, which is relevant to his own traffic case that he lost and is now trying to appeal. So while that's going, I am going to get a refill. So give me 1 second. Everybody. All right.
Kim Blandino appearing for the appellant pro se.
Currently, over on Your Honor.
Who are
This would
you?
be Stephen Dempsey, that for the record, he's not going to be representing me or in any way appearing as a licensed attorney. He's just there to help me take notes and keep things. You have allowed that in a case in which some people from India, and you let Mr. Lawrence Sparks sit at the table. I saw a minute order on the record in that case.
All right.
I think it would be improper
Hold on
to
a
deny it
second.
here.
Hold on a second. Mr. Dempsey, I don't know what relationship you have with Mr. Blandino, but let me just ask you, are you a Nevada lawyer?
Definitely, I don't believe so. I'm not a licensed attorney, if that's the question.
Well, if you're not a licensed attorney, that would be that, no, you're not a lawyer. Given that it's your case, I'll allow him to sit with you. But he can't really do anything to assist you because, to me, I've got to be careful now, and so do you. I don't want any unauthorized practice of law. Mr. Dempsey?
Yes.
He's not a lawyer. So
I don't think it'd be improper if I start getting a little overheated, he could say, calm down, and write a note, calm down, maybe settle down. That wouldn't be legal advice, I don't think.
Okay, I'm going to allow him to stay there for now. I just expect him to conduct himself appropriately and not do anything to actively represent you. He's not a lawyer, but if he's a friend of yours, under these circumstances, it's your case, I'll allow him to be there, but I expect him to just, of course, maintain his own civility, okay?
For the record, he was allowed to sit at a felony trial that I had back in 1995, but then Judge Maupin, now former Justice Maupin of the Nevada Supreme Court, and he allowed him to sit there as well. So it's not unprecedented what you're allowing today, and it's appreciated.
All right. I just got a note, though, that, Mr. Dempsey, you have a matter with the court today? It's not an argument. It's,
It was to set a briefing schedule, but he had representations.
Why?
Right, and I'll be sitting to aid him in his case. It's serendipitous that
okay. Well,
we have a case
here's
here
the
at the same time.
situation. That changes things, in my opinion. If somebody comes into court with a friend and I decide I just want to let the friend sit there, that's one thing. But I'm not going to have a situation where litigants that aren't lawyers help each other and all that by sitting at counsel table. So, I just got this note. I didn't know, Mr. Dempsey, that you had a matter on calendar today, because I'm prepared for all the arguments. Yours is an administrative setting, and I involve myself more with the arguments in my preparations. So what I'm going to do, because you do have a case with the court today, I'm going to ask you that you stay in the back of the court and that you not sit with Mr. Blandino and vice versa. I'm not going to conduct court that way. So that's what I'd like for you to do.
I'm going to have to object. I don't see
You
how
can
that...
object all you want.
How does that in any way change?
That is my directive.
I know.
So,
I
Mr.
mean, I'm not
Dempsey,
denying
you
that
gather
one.
things
No,
up
no, no.
that are
Don't get me wrong.
yours, and please go into the back of the court.
I have personally witnessed some really shitty attorneys. Do not get it twisted. They exist.
And when we call your case, we'll handle your case.
Thank you.
Okay.
Thank you, Beat. At
All
least
right.
somebody
In Mr.
does.
Blandino's case, I do want to start with mentioning that I did grant the City of Las Vegas's motion to limit the appeal to the issue concerning a motion for new trial that was dealt with in the lower court. And just to set that procedural timeline, there was a judgment entered against Mr. Blandino in the Las Vegas Municipal Court on October 7th of 2014. He filed a motion for new trial on October 20th, 2014. Trial court denied that motion for new trial on October 30th. He then filed a notice of appeal on November 6th. And so, as my order reflects, what that does is it makes it such that the appeal in our court would deal only with the motion for new trial being denied. That's your understanding of it, isn't it, Ms. Halbert?
Yes, Your Honor.
Of course, I
So in other words, the reckless driving conviction itself is not on appeal.
That's correct, Your Honor.
All right.
Yes, this is a Fallout Pit Boy sweatshirt. It's my ugly sweater for the holiday. Anyway, to reiterate what the judge just said right there. What he's saying is that Kim is not appealing the conviction itself. He's appealing the denial of his motion for a new trial. Oh, I don't know why, but whatever. So, yeah. But just to clarify, that's what the judge is basically saying in Kim's action.
Well, I just, for the record, I need to object the way you stated it. There was, if you're saying the word entered, there was no signed judgment of conviction, as my notice of appeal stated. That's why I put alleged. You know, the city does not want to comply, and the city judges downstairs don't want to comply with 1089.010, which means a signed judgment of conviction. And it distresses me that...
Okay, I actually looked up this Nevada statute, and I didn't see anywhere. If he kind of misquotes the statute, but the closest one that I was able to find what he's talking about, it doesn't say that the judgment has to be written. Only that it needs to be a judgment. But I digress.
That you're not looking at the record on these matters, nor requiring the city, nor the 89.010, which means a signed judgment of conviction. And it
Mike, if you're here, you'll like this.
Distresses me that you're not looking at the record on these matters, nor requiring the city nor the state in those cases from justice court to present the record to you, because...
All right, let me tell
So he's basically accusing the judge of like not doing his due diligence or not even paying attention to the record. He's accusing the judge of being sloppy. It's not the best tactic to make in front of a judge, but it gets worse. It gets worse.
tell you, Mr. Blandino, you can make your arguments to me either consistent with your brief or related to your brief, but I don't think it's a good way to do business here to tell me what you think I'm doing and not doing. All right, so go ahead and continue, but I'm going to ask you to not draw conclusions as to what I'm doing.
Your Honor,
and
I
not
would like a
doing.
sidebar conference for a matter that I wanted to bring up.
Here we go.
That is sensitive in nature. It has been presented in the pleadings, because in the past you would not accept a sidebar conference, but I think it's more than appropriate now, if I may.
We're an open court. Go ahead. You don't need a sidebar. Tell me what.
Well, it's of a sensitive nature.
Well, I'm not going to do that. Make your argument having to do with your appeal.
I think that Carleen Helbert should recuse herself from participating in this matter because from all appearances, and I've checked with outside sources, so it's not just my perception, is that there's some kind of interest of a romantic or affiliatory, friendly nature that goes beyond the court. You twice have...
He just accused the judge and the prosecutor of having an affair in open court.
Noted that elevated her to having a rule in her name, the Helbert rule. You stated on 2 separate occasions where somehow there's some briefing schedule of 120 days, and you have
Hold on a second.
You
now.
have shown
Hold on a
animus toward
second.
me.
If
and
I'm talking to you, I
favoritism
want you
toward
to
her.
let me talk to you.
Yeah.
Sounds like are you alleging that there's some kind of relationship between me and Miss Halbert?
What I'm stating is what that I've seen is improper and maybe the overtures toward a relationship that, as I cited in my moving papers, that if Judge Jones had done this precautionary thing as well, and I asked the court to take judicial notice that this former family court judge is about to be sentenced or has been sentenced, going to federal prison for improper, and part of the improper nature which the district attorney had to file a complaint to the Commission on Judicial Discipline.
All right, I want to stop you at this point because, frankly...
And part of the improper nature which the district attorney had to file a complaint to the Commission on Judicial Discipline.
All right, I want to stop you at this point because, frankly, this is a ridiculous argument in my opinion. So go ahead and get to the merits of your legal matter, and I'll deal with that.
Well, from what I understood, if I look on the calendar, although not on the sheet, we're here for 4 different matters. And there's a status check. I had to file a new appeal on the transcript issue down below.
It also gets even worse. It also gets even worse. Let's listen in.
So they're trying to, again,
Mike, you'll
argue
enjoy
that
this.
that appeal, the new appeal, isn't before the court. Are you familiar with that record?
Well, let me ask Ms. Halbert what she thinks is on the table today. I do have the motion to dismiss the second appeal for lack of jurisdiction that you filed.
That's correct, Your Honor. I had to, quite frankly, I had to look at the court's calendar to determine what exactly was on today as well as there's a plethora of pleadings. There is some sort of motion, on Your Honor, for an order to show cause. I didn't respond to that. I thought that was improper in itself, and not even a thinly veiled threat, but a threat. The notice of hearing.
Oh yeah, that motion is entitled Motion for Judge
Listen to this motion. Listen to this motion.
Baer to show cause why appellant or others should not file a complaint with the Commission on Judicial Discipline, and for corrective action to avoid the necessity of filing said complaint. Do you have any position on that?
He filed an order to show cause on the judge himself, demanding that he explain why Kim shouldn't file a complaint against the judge with the Nevada Judicial Commission. He basically filed a threat to the judge. Basically saying that if you don't do what I ask, I'm going to file a complaint against you with the Judicial Ethics Commission.
I think that should be dismissed. It's improper. It's a threat, and I don't see how he can serve a motion on Your Honor who is hearing the case.
Okay.
I don't think there's been a legal basis provided. The notice of the hearing and my motion to dismiss is essentially Mr. Blandino demanded that the municipal court provide the transcripts. The trial court denied that demand.
For a fee. If I may interject, for a fee.
If I could just finish, Mr. Blandino, I've been polite enough not to interrupt Mr. Blandino when he's
Sure, go ahead, Ms.
Yeah, I hear that tone in her voice, and honestly, I would be just as pissed off as she is if my integrity was being challenged by the notion that I was having an affair with the judge. I'd probably be pretty pissed off too. So, yeah.
Again, there was a notice of what happened is the trial court denied Mr. Blandino's demand that they pay for the transcripts. He filed a notice of hearing, or I guess what would be an appeal on that, and that's where my motion came about, is to dismiss that appeal for lack of jurisdiction. Again, because I can go into that when it's my turn to argument, and then there is the status check regarding the transcripts, and I believe on April 29th, Your Honor ordered Mr. Blandino to provide the transcripts or threatened that the appeal would be dismissed.
Okay.
She left out, though, the other thing was the appeal of the order, and it was a signed order. I actually got Judge Roger to have a signed order done, which I reviewed after the city attorney prepared it.
All right, so this is your
appeal of a motion to correct the
Right.
illegal sentence, and they're saying also that that is not properly before the court. But my response orally to that would be, well, if it's not an appeal, then it's going to be like an informal pauper status or motion for stay.
Right.
If I can't appeal it, then it's renewable here.
All right, here's the situation. You want to sit down and listen to me for a second,
Yes.
Mr. Blandino? In open court today, it seemed to me that you alleged really some unethical conduct on my part by averring to a potential bias I might have against you or some favoritism for Ms. Halbert. You know, I do, just to let you know and let everybody know, I do have friendly relationships with a lot of people. I'm lucky that way. When I run for office, I have to say yes to 200 lawyers that want to be on the committee to reelect me and tell another about 150, sorry, but I've got 200 already. So I've been lucky in my career to make a lot of friends. Life has brought me some good things. As it turns out, the relationship, I'll tell you, between Ms. Halbert and I is professional only, in that I do this with a lot of lawyers that do a good job. I'll give them compliments in court. You're right. There's a way of doing business that Ms. Halbert has shown to be good. And it's these little check sheets that she has in her briefs that I think are a wonderful way to write an appellate brief. So I've complimented her on that. I've complimented a lot of lawyers that have been in court, though, both from the defense side and from the prosecution side. There's even the Pileski protocol from something we did a long time ago where Ed Pileski represented the city, and I complimented him on his work. I've complimented Mr. Nelson here a few times as well. And so it happens
Turn
that
down
way.
that volume of the alert.
As it turns out, I don't believe I've ever even talked to Ms. Halbert on phone, email, or in person in any place other than court, ever, as far as I know. I might have seen her in the hallway.
This is like a part one of this series, and we're gonna end part one at a particular moment, and we'll be getting to that towards the end.
Once and said hello or something, but that's the extent of it, just so you know. So that allegation
that does involve this judge, I should say,
combined with the motion that you filed, makes me think about things a little bit. There is a Nevada Supreme Court case entitled Stuff, where attorney Michael Stuff came into a courtroom in front of Judge Huffaker.
Do you have the citation on that, Your Honor?
I don't. And threatened to file a disciplinary.
Jassa, we're watching in chronological order. These are the earliest videos of Kim Blandino that I've been able to find on YouTube.
Complaint with the Nevada Commission on Judicial Discipline. The Nevada Supreme Court found that as a lawyer, Mr. Stuff was guilty of misconduct for making such a threat, and they gave him a public reprimand for that activity.
Basically, the judge was reminding Kim that an attorney tried your tactic before, and he was smacked down by the Nevada State Bar for misconduct.
I need to think about what's going on here in regard to these sort of allegations that are similar to that you've made. Further, I need to just take under advisement everything I have here, and so that's what I'm going to do. Go ahead and call the next case.
Thank you, Judge.
Next case is gonna be page 21. That's case number C-15-306-563, Donald Claussen versus City of Las Vegas.
Now, watch this. After everything that's been happening so far, watch what Kim does next with this next case.
What is that again?
Page 21, Judge.
What are you doing?
Mr. Claussen?
Yes, sir.
All right, Mr. Blandino.
Mr. Blandino. What?
You're asking me, I'm here to take notes from Mr. Claussen and help him in that regard.
All right, I'm not going to allow that, so go ahead in the back of the
Okay,
courtroom.
well, we have it
or
on
you
record
can
now,
leave.
thank you.
Okay.
I believe he has talked with these litigants beforehand.
All right. Mr. Claussen?
Yes.
In fact, actually, there is I did find a court case on Claussen and where Claussen and Blandino were co-plaintiffs. It was either a federal or Nevada appeals court case.
I'm here today to deal with the City of Las Vegas's motion to dismiss the appeal for failure to prosecute it. The initial appearance in our court was, looks like June 24th. What are your intentions regarding
I would like to further
going
the
forward?
appeal. I didn't receive any notice of the June 24th hearing until after the fact, so there's no way I could reschedule or...
Okay, I understand. Ms. Halbert, where do you think we are procedurally on this?
Judge,
Transcripts or no?
I have some concerns with Mr. Claussen, as there's various things in his file now where Mr. Blandino has scratched off his own name and written Mr. Claussen's name, including a letter to Narita's supervisor.
Let's listen to that again. I'm gonna up the volume to make sure you guys heard what the district attorney just said there. I'm gonna up the volume.
Okay, I understand. Ms. Halbert, where do you think we are procedurally on this?
Judge,
Transcripts or no?
I have some concerns with Mr. Claussen, as there's various things in his file now where Mr. Blandino has scratched off his own name and written Mr. Claussen's name, including a letter to Narita's supervisor, a notice of consent for electronic service, which lists Mr. Blandino's email address rather than Mr. Claussen's email address.
Okay.
I don't have a problem withdrawing my motion.
So he wrote up filings and scratched out his name and put Claussen's name to make it seem like Claussen was the one who filed these these papers and motions. But he did it so shittily that the district attorney was able to see that Blandino's name was originally on the pleadings and on the motions, and also didn't even bother to put in Claussen's own email address. That right there is unlicensed practice. He is writing up papers on behalf of somebody else.
Today, because the defendant has appeared, but I would like to express some concerns on the
Okay.
record as far as the transcripts. I just don't believe it's...
All right, so the motion is withdrawn, and that means, Mr. Claussen, there's no further motion to dismiss your appeal, and that puts us back to where you just have to get the transcripts put together. I gave you 30 days to do that. I think that's fair and reasonable.
Could I ask for 60? I'm from out of town and...
Okay, I'll give you 60, no problem. 60 days, what's that return? That's just a status check, return date on transcripts.
That will be September 23rd at 10 a.m.
So you have until then to put the transcripts together. We'll come back to court on that day and figure out where to go from there. Where are you coming from?
I split my time between Sapporo, New Mexico, and Kingman, Arizona.
All right, well, that date, what's that date again?
It's September 23rd.
Is that a convenient date for you to be here?
I'll make it so.
Okay, but I'd ask. If it wasn't, I'll give you a date around then, based on your travels. But if that's going to be a good date for you, that's fine.
I prefer it that way because I'm in the agricultural industry and
Okay.
that's when things start to slow down.
All right, so just to be sure, when we come back on that day, you'll have I'll expect that you'll have the transcripts ordered, paid for, or provided, and we'll then set a further court schedule on that day, okay?
Okay, so you're going to order me to get the transcripts?
Well, yeah.
You're supposed see again the fact that he said that again knows that he's been talking to and is being coached by Kim, because as you guys know, if it's not as Kim likes to say in a lot of these videos, Kim does not like to do anything unless it's explicitly and with particularity on a written order, and he will find any avenue in which to not follow orders from the court.
I mean, that's the first part of the appellate process. You've got to get the transcripts put together. Okay?
Very good.
All right, what's next?
That's the last of our polls of everybody that's checked in.
Okay.
We're still waiting on Mr. Weaver. He has quite a few cases on calendar today. No?
I haven't seen it.
He's gonna come in. Victims. Sorry. One.
Your Honor, Bruce Nelson appearing on behalf of the state of Nevada.
And
good morning, Your Honor, Bruce Nelson.
And here we go again.
Nelson appearing on behalf of the state of Nevada.
What did the judge already told him you're not going to be sitting next to him on his case. Why?
Stephen Dempsey.
Mr. Blandino, what part of what I tell you do you care not to listen to?
This is a new case, if I may, Your Honor. We need to.
All right, here's the
record.
situation. I'm going to tell you to stay in the back of the courtroom. If you disrupt the court one more time, I'm going to ban you from the courtroom.
Your Honor, I asked him to be here. He's not disrupting anything that I'm aware of.
I've made my decision that people that have cases on the same day, I don't want them participating with each other. It's awkward for a court to conduct business that way. It is a decision I've made. I'd like for you to respect it.
Could I be heard on that issue?
No.
No.
You're going to be heard on what's happening in your case.
Very well.
As I have it, the transcript hasn't been filed. Mr. Nelson, where do you think we're at?
I think Mr. Dempsey would need to obtain the transcript, Your Honor.
All right. How much time do you need to get the transcript? I'm asking you a question. How much time?
Can
How
I
much
be
time
heard
do you?
for the record, Your Honor?
Sure. Go ahead.
I think that a criminal case.
Again, here we go. Talking about him not wanting to pay for the transcript. This is now the third litigant who, other than Blandino himself, who's trying to make this case. Which tells me, which suggests to me, that Blandino has been directly involving himself with these other litigants. He's not an attorney. Bear in mind, he's not an attorney.
And the defendant, if convicted, has a right to an appeal. Is my understanding, based on what I see happening in these proceedings and other similar proceedings, that the appeal.
In fairness, Trek, a transcript is not cheap. In fairness, a transcript isn't cheap. However, in most jurisdictions, I can't say all, but in vast majority of jurisdictions, you can make a showing of indigency, and get the transcripts for free. However, the ability to get those transcripts for free may depend on, the crime alleged. So, for example, if the crime is something petty, like, for example, a traffic case, you may not have that right, the ability to claim indigency. I don't know. I'm not sure. I'm not 100% sure on that. It may be that if you're convicted for something more serious, then you're able to make the claim for indigency in that regard.
Is on the record. I believe that the transmittal of the record on appeal is supposed to include a transcript.
Okay, I can't,
Since it's on the
Mr.
record.
Dempsey, I can't change what opinion you may or may not have.
I'm asking for clarification, Your Honor.
All I can do is set a hearing to see if you have done anything having to do with the transcript issue. If you want to file something to try to convince me that you don't have to do that, file away. But I'm going to set a status check in 30 days to see what's happening with this transcript issue.
August 19th at 10 a.m. for status check.
I'd like an opportunity to be heard for the record.
I've heard enough from you. Okay, what's the next case?
I've heard enough.
Again, that was last week. That's still waiting on Mr. Mueller.
Miss Halbert had told me that Mr. Mueller was apparently down in municipal court.
That's page 15.
I don't think he's in this one.
15-30.
All right, let me see.
Office and this.
Oh, okay. This one does not involve Blandino, but I want you guys to hear the circumstances surrounding this plea deal, just real quick. It's only a minute and a half. I promise.
15-306986 Jacqueline Byers versus City of Henderson.
Erica Gold on behalf of the City of Henderson. Your Honor, we got a briefing schedule on this, but I believe we have the matter resolved.
All right, let me see who's here for Ms. Byers.
That's correct. Norman Mark Rolls from the Henderson Municipal Public Defender's Office and Miss Byers.
Okay, Ms. Byers, go ahead and have a seat and relax. What's going on? What's the arrangement?
Your Honor, I think we have a negotiation that Ms. Byers would be pleading no contest with a state adjudication, 30-day suspended sentence, fines of $305, pay for and complete an anger management counseling class, complete 48 hours community service, and have no further arrests or criminal citations for 1 year.
Okay, so 30 days suspended, $305 fine, anger management courses, and 48 hours of community service, and 1 year of don't do stupid shit.
Entry that plea and acceptance of it, we would withdraw our appeal.
All right, is that acceptable to you?
That's correct, Your Honor.
Ms. Byers, do you understand that? Is that what you want the court to do?
Yes, I do.
All right, that'll be the order of the court. Okay.
Then admitted to a breach of peace without fighting.
And that it was that the guilty plea was to be amended to be breach without violence, breach of the peace without violence. Which I'm thinking to myself, what? I mean, if she's pleading to that and she's getting that kind of a sentence, that seems pretty high for that kind of a sentence. But
upon completion.
Again, is that part of the deal, Ms. Byers?
Yes.
Okay, that'll be the order. I want to remand it back to the city court for further proceedings, whatever they may be. Okay?
Thank you, Your Honor.
All right.
And just for the record, what's the original charge, Judge?
The original charge was battery domestic violence first.
oh, the original charge was first-degree battery and and domestic violence. Oh. Oh my. That's why the plea deal is what it is. Woo.
What's the original charge, Judge?
The original charge was battery domestic violence first.
Oh.
Thank you, Your Honor. See Mr. Mueller's here. I'm not
Okay.
sure if he's ready to go.
Before we get into these arguments,
I don't know. I just thought that was hilarious because of that grand reveal at the end. It's like, what the hell was he charged with? Oh.
is there anybody in the court that has something other than an argument that you feel as though we
Filed with the court. I don't know if we're set for argument.
do?
Yeah, I believe the state of back.
And
I had it down as 10.
C-15. Okay, 20 for argument and
Thank you.
All right, Mr. Call your case. You want,
Up to the position out of state.
you have any?
August 19th for the transcript as they have not.
The reason why this is in the playlist is Blandino's still back there in the back of the court.
You want more time than that? Do you have any objection to giving him more time?
Your Honor, I asked that he get the same 60 days as everybody else.
You want 90 days?
That's what I asked for, because I've accepted a position out of state, and it's going to cause me problems. I know I'll be back in 90
Okay,
days.
here's what I think a good accommodation to it would be then. I'll give him the 90 days. What's that return date?
The 90-day date will be October 21st at 10 a.m.
All right, but my mindset would be, since I've given you all that time, that if you don't have the transcripts provided by that date, I'd be inclined to entertain a motion that day to dismiss the case. So you have the 90 days. We can make it part of the record that that would be my mindset if you don't have the transcript. on that day. What is that day again?
October 21st at 10 a.m.
Okay.
Well, I would certainly be able to be heard on the issue at that point, though, correct?
You'll be here that day, it sounds like to me, and we'll deal with it. Okay?
I was here and I couldn't be heard, so I just.
All right, I understand.
clarify
I
that.
understand.
Thank you.
I listened to you. I recalled your case.
I
So
appreciate it, Your
that's
Honor.
it. Okay?
Have a good week.
All right. What's next?
On page 13. Case number C-15-307-407.
Honestly, watching this makes me miss my law clerk days, and honestly, I would love to be back in the courtroom.
Alda Anderson versus City of Las Vegas.
No, nothing from Mr. Blandino from there.
Good. In this
Nothing.
appeals,
Okay, this is not. This is also doesn't involve Blandino, but honestly, some of these cases, I should probably post it. They actually do have some fascinating appellate arguments from actual two lawyers who know what they're doing, and they're actually pretty interesting to listen to. So I actually would have advised, if you're a nerd like me who enjoys these kinds of like appellate briefs, actually that is actually what I would love to do. I would love to be an appellate attorney. I love, making my case in front of a panel. It just hasn't worked out like that yet. That's what I would really love to do if I'm being honest.
You like the consent?
Erica Predamore versus
Erica, she's present out of custody. Erica?
come on, and quick. Going out. Some problem with staying out of trouble. I do disagree with the rest. Stayed out of trouble or didn't stay out of trouble.
This is another one. 25 minutes. It also talks about one of them was dealing with Nevada's implied consent law when it comes to DUI and your consent to provide either blood sample or a breathalyzer. And this one was also another issue I can't remember what this was, but this was also a very fascinating one as well.
It's, quote, must be made before trial.
347, Haley Godwin versus City of Las Vegas.
And he's still here. By the way, he's still here. He's been. We're at 11:30. This guy's been in this courtroom for the last 2 hours.
And no one appears to be here, Your Honor. I'd ask for the August 12th date.
Yeah, why not? Let's do that.
August 12th, 10 a.m.
Can I ask that a case be recalled since you've already done that once today?
Is it the end of the calendar?
Yes.
And Your Honor, just as
he's just fucking ignoring him.
Record, going to request the court order Miss Halbert buy me lunch because I'm doing all these.
Ah!
I'll tell you what. If you draft it, I'll sign it.
I'm going to ask.
-15-307-133, Michelle Volkson versus 307-079, Wendy Cardenas versus City of Las Vegas.
Recording device.
He's still here.
Set over the next calendar, and
Was something else.
That Satow?
Yes, the towel.
Health doesn't look like Mr. Satow is here either.
Page 8.
And then.
Where are you? Page 8.
Yeah,
all right.
That one. Then last page is page 19.
19.
And that's case number C-14-300.
So, okay, now we're getting to the tail end of tonight, and the ultimate conclusion of this part one of this series. The initial is another general appellate brief, appellate arguments that are being made between counsel. Blandino arrives at the end of this because, again, he's sitting in the back for some reason.
Which I've had a lot of patience with over the years. I find patience, but
so
record and Mr. Blandino. Okay.
Here we go.
All right, I want to stay on the court record, and Mr. Blandino, you're here in court. I want to talk to you. And
here we go.
You can stay right where you're at, or you can come on up here and sit at the council table.
Well, the courts are public. Generally speaking, they're public. Any member of the public can go into virtually any case and sit on it. Generally, there are exceptions, obviously, but they're supposed to be public, and I encourage that, and the judge will emphasize that he encourages that too. You don't have to be a member of the suit in order to just go to your local courthouse in the middle, if you have the time and aren't working, to go to your local courthouse and sit in the public gallery and watch motions hearings. They're open to the public as in my opinion they should be. So there's nothing wrong with that inherently. It's just Mr. Blandino goes beyond mere observation.
Okay. Are we on the record on my case, my appeal?
No, we're not on the record in your case. We're just on the court record. I understand you do have a case with our court president.
Okay. Then I'll just state my appearance. Kim Blandino, appearing pro se for Kim Blandino.
All right. Now here's the reason I want to talk to you, and I want to take a few moments to talk with you. You're welcome to have a seat if you want to take notes. In fairness, I just need to do what I need to do now, and so I want to talk to you.
Play out. I'll be right back.
Mr. Blandino, I want to tell you that, in my opinion, and in this situation, I've made a decision to allow you to talk with me about it. I don't think I even have to do that, by the way, because in the event I were to feel as a judge that there has been what's known as contempt of court committed within the presence of the court or me as a judge, the law allows me to summarily punish that. That's NRS 22.030. So I could, in my view, if I wanted to, simply punish what I would view as contempt committed in the immediate view or presence of the court, whether it's my staff, that being the clerk, the recorder, the marshal, or me as a judge. I could punish it summarily, in my opinion. But
y'all wanted contempt, you're about to get contempt. There you go.
We've been around our court on numerous occasions, and I just thought, I made a decision, and maybe it's stylistic, but I made a decision. I at least wanted to talk to you about what I've been thinking and what has continued to evolve having to do with you. So that's what I'm doing right now. Okay? Here's what I think. We did have court upstairs in Judge Tagliotti's courtroom on July 22nd of 2015, so relatively recently we had court up there. And in a couple cases that I had that day...
So now, if in case you missed it, he's referring back to July 22nd, all of what we watched previously.
In that courtroom, you made appearances for a couple of the people that didn't have lawyers.
Can I object to that?
Let me finish what I want to say, okay? In other words, you were in the courtroom, you came up, and you made a request to participate, to assist people. That's what it was. You made a request to assist those people who didn't have lawyers. And as you recall, it got to a point where I asked you not to do that, and I asked you to just sit in the back of the courtroom. But nonetheless, it happened on a couple of occasions there on July 22nd. And, I don't have that transcript in front of me, but I know I said some things to you consistent with my thought that I would like to ask you to stop this, because I did view it as inappropriate and a bit of an interruption or disruption of court proceedings. So that's what happened on Wednesday, July 22nd.
Which I did stop at that point.
I understand. Now today, before I came into court, I was informed by my marshal that there was a point in time earlier this morning where you came in and you addressed our clerk.
Yes.
And you did that in a case C15-307-950A, known as Darcy Lee Ogden, AGGEN, versus City of Las Vegas.
So the judge is saying that today he went to his clerk, the court clerk's office, or his clerk's office, his clerk, to inquire about a case in which he is not a party to.
And you also addressed our clerk, as I understand it, in a case called case C15-307-960A, known as Jermaine Gomes versus G-O-M-E-S versus.
He did it twice.
Yeah, and that was an error. To correct the record, I spoke to the wrong case. It was the Blake case. I had the names wrong.
Okay, but in any event, it's my.
No, that's incorrect. It was another case. It was a different case in which I'm also not a party to.
I understand you came up and you addressed our clerk on two cases that we had pending that were not your cases. I mean, you came up to the clerk and you talked to her. I do have, and I asked my clerk to make copies of those 2 pages that you addressed her on, and you can see in her handwriting here, she's writing Kim Blandino next to the appellant's names, both Jerome Gomes and.
Wait. He wrote.
Pages. I asked my clerk to make copies of those 2 pages that you addressed her on, and you can see in her handwriting here, she's writing Kim Blandino next to the appellant's names, both Jerome Gomes and Darcy Lee Ogden. She writes Kim Blandino. And I think that my clerk would tell you that that's because she felt like when you came up here to address her, and she's checking in people for their cases, that you are appearing on their behalf. You represent.
So basically, what the judge is saying, like, because of the way Kim approached the clerk, without knowing that Kim isn't an attorney, assumed that Kim was the attorneys for both of these appellants, and wrote his name next to them.
Presenting. That's the conclusion that my clerk would have drawn.
No, I made that clear that I wasn't.
What do I think happened? Okay. And I'm going to give you a chance to respond to all this, even though I don't think I have to. I'm going to do it that way. And so, here's what I'm telling you, and I know you're listening to me. This has been adding up for a while, and I'm not even getting into other things that have happened between you and the court staff, or you and the lawyers in the cases, or you and me in past occasions, but there have been, in my view, other disruptions, but I don't even need to get to those. I just want to generally mention to you that there have been some disruptions. But again, on July 22nd, we had that incident, or a couple incidences where you tried to sit with people. I told you to stop it. Again, today you came in and you checked in with my clerk on at least two cases that I've mentioned where they're not your cases, and as I understand it, you're not a Nevada lawyer. I mean, that's for sure. You're not a lawyer anywhere. And so that happens. Then, when the Gomes case was called, that again being C-15-307-960A, you sort of participated in that, at least attempted to initially, and I told you not to do that. The same thing in that Ogden case, Darcy Lee Ogden, the two cases. So, what I'm here to tell you is, I don't take a lot of pleasure in this, but I feel as though what has happened and what continues to happen, and I see it too from Ms. Helbert, who just happens to still be here, and her saying to me, look, I'd like to request that when, this is Ms. Helbert asking me a few minutes ago, where she says she wants to talk to a litigant who's not represented by counsel, that I've tried to help that litigant by asking Ms. Helbert to give some procedural advice on how to maybe get transcripts for free. Ms. Helbert says to me, can you enter an order that I can do that without Mr. Blandino being involved in it?
So now you have the district attorney asking the judge to ensure that in future filings for this pro se litigant that Kim isn't involved in it. In other words, he's a busybody. Again, a busybody / interloper. He's involving himself in cases to which he has no business being involved in.
And all these things have just added up over time to where I have to tell you, I think you're involving yourself in unauthorized practice of law. In addition to that, I find that this is contempt of my court. It's interrupting the court. It's making it so that the business of the court is being hindered. I find that it's conduct that's disturbing the court. It's happening in the presence of either the court staff or me as a judge. And it interrupts the due course of judicial proceedings that I'm duty-bound to involve myself with as a judge. So I want to just stop here. And I don't have to do this, but I want it in fairness to you, because it's my style, tell you that I find that it's my view that you're in contempt of this court and I need to do something about it, but I want to just give you an opportunity to tell me what you'd like having to do with my thoughts. So go ahead, if you'd like to. You don't even have to.
Well, no, I absolutely have to and want to, because I am just the opposite. I'm trying to be a help to this court. But I want the court to follow the law and to follow the rules, to follow the statutes. I object to the fact that you've mischaracterized it, and that I was never appearing for anyone, and I made that absolutely clear on the record, just to help take notes.
Don't worry, it actually gets even better, the fact that he allows him to speak. It gets better.
To sit next to him, and I wanted Steve Dempsey to sit next to me to help, which you disallowed on that same date. You didn't reference that case. You disallowed him sitting there only on the fact that, and on that specific fact, that Mr. Dempsey was already a litigant and had an appeal before that court. Now, you didn't make a distinction as whether because he was appearing on his case that day or would generally be. It didn't. Yeah. And as to those instances, and you have mentioned and you touched around some of these other instances where you would ask, does anybody have anything else? And I would raise my hand in court. The very first time you said, does anybody have one of those information sheets on transcripts? And I raised my hand because I had one and you didn't acknowledge me then. So there's been cases when you have an invited participation from people in the gallery. Even when you say good morning, when we come in, I don't know if you hear among the cacophony of voices.
He's conflating his interjection in other people's cases with people saying good morning to the judge when he walks to the bench for the first time in the morning.
But I say good morning because you're saying good morning. It's only right to do that. If somebody says good morning, it's polite to say good morning back. Is that contemptuous, Judge? I don't think so. When you
typically saying good morning wouldn't be contemptuous, I'll give you that. I'm talking about, again, this repeated course of conduct in my court, which I've had a lot of patience with over time.
There's no doubt you have patience.
I'll tell you something, Mr. Blandino. You can either believe it or not, but I'm telling it to you from my judicial heart, if there is such a thing, okay? I love the fact this is a public courtroom. You know, I don't care who comes in the courtroom. The doors are open. The only way that the public, in my view, can get a sense as to whether justice is actually being had is to come on in here and sit down as much as they want and watch what happens in the public courtrooms. That's sacred to me. It's important to me. So for me to do something to curb that in some way, it would take a lot. But I'm telling you, this is that situation for me, and I pretty much had it.
But I have an explanation for every one of these items, and it's perfectly logical, and I can take them point by point as you brought them up. That when you've asked for participation or acknowledgement from me this morning, when my name is mentioned by Carleen Helbert to a case that I had talked to the person, I'm not denying that, I talked to Mr. Gomes, but I just wanted to get some information as to whether he got notice of this thing, because I've been looking at the records on all these cases.
I know, but you have to understand, in my view, you shouldn't be talking to litigants that you don't have any friendship or relationship with other than seeing them here in the court and giving them advice on their case.
Is it against the law to talk to other litigants?
I think what you're doing is, actually.
Kinda. In what you're doing? Kinda.
Let me just tell you, if you look at NRS 7.285, it is a statute that defines unlawful practice of law in Nevada.
Well, I have not done that. I've never held myself out to be a lawyer. or a licensed member of the bar.
You don't have to. You don't have to present yourself out as being a lawyer when you're not to be charged with unauthorized practice of law. The unauthorized practice of law, for example, would be generating and filing papers on somebody's behalf, right? Giving them bona fide legal advice. You don't have to explicitly say, you know, I am a doctor, and also be charged with the unlicensed practice of medicine.
In any way, shape, or form.
I understand. You don't have to do that to be guilty, really, of unauthorized practice of law. But if you have a pro se, if you have a litigant that comes to court without a lawyer, and they run into a guy, Kim Blandino, who then gives them advice, procedural advice on their case, wants to sit with them at counsel table and help them out, to me, that's the practice of law. That's what lawyers do. That's not what some member of the public can show up in a courtroom and just start doing. And that's
But
what
you cannot cite to one instance where you viewed it in your person or it's been reiterated by Ms. Helbert and in affidavit form presented to you where I've not given legal advice. Look, I'm a law librarian.
You're a what?
A law librarian is not giving legal advice. If I say, look, you got this statute here, that's not legal advice. If I say there's a stop sign there and you should obey that, that's not legal advice. It is not. It's what the law is. If you yield sign, if I'm, you've heard the expression backseat driver. Hey, you better slow down. You're going faster than the speed limit. Is that legal advice, Your Honor? No, it is not. It is. And what I've done in every instance here is I've talked to litigants and I'm trying to share and see what's going on with the records.
How many litigants have you talked to?
Administrative and
How many litigants have you
procedural.
talked to during the time you and I have had involvement with each other in these misdemeanor appeals?
How many litigants have you talked to? That's a good, hold on.
How many people have you talked to that come in here without a lawyer, you take it upon yourself to talk to them? About how many?
Well, I got to ask you that question.
I'm asking you, about how
Can
many?
this information be used against me in a contempt case? Because it seems like you're on the verge of doing a contempt case against me.
Now that, I agree with the judge, is a very good question.
That is probably a good question. I'm looking at this in regard to civil contempt, but because it's also a potential crime of unlawful practice of law.
Fifth Amendment would
apply.
apply.
You don't have to answer that question.
So the judge correctly says, you know what? That's a good question. So, you don't have to answer that because you can actually plead the fifth on that one because this might actually be used against you in a potential criminal action against you for impersonating or the unlicensed, unauthorized practice of law.
Thank you. So what I just did here was I giving you legal advice. No, I was just exposing that part of the law so that you could see it. Law librarian style or questioning style, Socratic method, if you will.
Okay. And by the way, you don't have to say anything to me. I'm not compelling you.
And now the judge is like, you don't have to say a goddamn thing to me anymore, by the way. You can keep your mouth shut at this point in time.
Well, no, I understand, but I want to explain
Let me make
because...
sure I get this on the record here between
Yeah,
you and I.
But the thing
most,
is...
Most people around here wouldn't be doing this.
No, I know. I
can tell you that
acknowledge
right now.
you're a very different kind of person.
But
You are
I
very
just
patient.
felt like if I'm going to remember, it's an odd circumstance I've never dealt with before, Mr. Blandino. I'll just tell you. For me, let me say this to you. For a member of the public, you, to come into the courtroom almost every Wednesday recently, fine. I'm all for that. I love it.
And other days as well.
Okay, that's great. I'm all for that. That's what a courtroom should be about, all right? But what I sort of got to was I said to myself, despite all my patience, despite all my warnings, despite all the things my staff tells me and that I've seen, I just sort of let it go. But I did give you little warnings along the way. Because I believe, let's keep the doors open to the public.
Yes.
All right?
And if I can get right to the specifics, I'm getting to every one of those specifics.
Okay, before we continue, do we think it would be in Kim's best interest to go into the specifics on how he's aiding these litigants. On the record, by the way.
Specifics that you cited, and I'll get to the big. When someone mentions my name in court, I feel it's only appropriate to stand up. I gave you an opportunity to see if because you could invite me, Mr. Blandino, what do you have to say? So I stand up to acknowledge so that you can see that I'm here. I mean,
Okay.
And
Let me make sure I say this to you so you know, again, though I think I've said it sufficiently. You don't have to say anything to
This is now the third or fourth time the judge says, you don't have to say anything, man. You do not have to say anything at this point.
me now. You can remain silent.
No, I do understand that. I do understand.
And I'm not reading you rights or anything. I'm just saying if you don't want to say something at all, you don't have to. I'm just saying that my style was in 4.5 years.
You're saying past tense was?
Yeah, well, you're going to see why.
Oh.
Okay.
Oh.
In 4.5 years here as a judge, I've never had something like this come up before. And I just said to myself, maybe nobody else in this whole facility would say the same thing. They might do it differently. I'm sure they would. And then maybe they would do things I wish I would have done. I don't know.
Foreshadowing.
All I can do is be. And I just simply said to myself that if I'm going to do something to prevent a member of the public from coming into our courtroom, I'm going to at least, as a matter of courtesy to that person, even though I don't like what's happened, I'm at least going to discuss it with them.
Yes.
Others might not do that, but I'm just doing it.
And I appreciate that, and that's fair, and that's why you're reasonable. In this case that I saw today, where you were agonizing over the 70-year-old woman, I could see the wheels turning in your head as to the compassionate aspects of that case and all that.
Thank you,
it's
Debbie.
Appreciated. But as of today, and which seems to be the breaking points, I know you're going to probably want to get to lunch here. When I came up to these, because of my diligent efforts,
Because of my diligent efforts. This is definitely a rhetorical question, but why is it that all of these guys seem to have like textbook narcissistic personality disorder? Allegedly.
This receipt for documents and notice of hearings that I first noticed in the Don Claussen case, so I admit that I talked to Don Claussen. There is no certificate that the certification that the person got, that they mailed out this notice of the first hearing. So when I talked to Mr. Claussen, I said, did you know you missed a hearing here? That's not legal advice, question. He said, no, I never got any notice. I said, well, these notices, they're flawed in a number of different ways. So I went up to Narita, the clerk supervisor, and I looked at all these different cases on the computer. Here's one from...
That's not your job. That's not your position to do. Like, you're engaging in the unauthorized practice, but even if you wanted to hide it, you would tell him to tell the clerk about this scheduling issue, not you go up there on his behalf. You're just making it worse for yourself.
Claussen, here's one from Lauren Sparks. These are the notice of appeal forms. This is, that's Sparks again, John Fleming. I've talked to all these individuals. And everything, they're all deficient. As a matter of fact, there's even a typo. It's been set for a hearing in Department 32, so they repeat department. I talked to Rita, I said...
Okay, at this point, I should probably interrupt you and tell you, if you want to continue to give this explanation to me or talk like this, this could be used against you by criminal authorities.
Now the judge is like, all right, dude, I'm going to actually tell you to stop right now. I advise you to stop talking. Because...
if they were to prosecute you for unauthorized practice of law. So my view is you have a Fifth Amendment right to remain silent. I will tell you that flat out.
Okay.
Because what you're doing now is it seems like, by showing me all this, you're admitting that you're pulling documents relevant to... Public
documents are public records.
Yeah, I know, but you have to understand, I can't let this happen.
But I showed Narita, I said, look...
Basically...
I know, I shouldn't have to be able to say this. It's not about you pulling documents from a public record. yes, most of these documents are a matter of public record that anybody can pull. They can request them. You are acting on those public records and are acting on at the behest or on behalf of a litigant. That is where you're fucking up. When I ask for the transcripts of a court case, like for example for the Miss STGB, I know her by acronym. I don't even, Ms. Bay from Philadelphia. I'm not using the transcripts on the notion that I'm going to represent her in court. I'm just asking for them as a public record. That's the difference that you're not, that's the distinction you're not seeing. And I think you know that that distinction exists, but you are being an ass clown about it.
In my view, you're representing people that don't have lawyers. That's my opinion. That's what you're doing. You can disagree with it, but I've got to do something to curb it.
But here's the thing, Your Honor. I went to Narita and I said, look, she filed a motion to dismiss in the Claussen case because he didn't show up for the hearing. He never got notice. I said, look, the first thing, whenever a protective order, restraining order, any kind of orders...
He's still fucking going. Even after the judge is giving him an explicit warning. Dude, stop. This can be used against you.
Filed in order to prosecute for contempt, the order doesn't just have to sit there. It has to be served on the person because the person was never served. You cannot, by law, violate an order you weren't served with because, you know, you can challenge it on the sufficiency of the service. Therefore, now Narita has since changed those forms, and that's why I was speaking to I was here this morning on I thought it was Gomes, but it was Blake and Agan. On both of those cases, in the new notice that they've now filed, that they're doing as a matter of record, Narita, the supervisor, got changed, and the first ones came up now here after I put that notice to their attention. They're doing a certificate of service on these. And on the Agan case and on the Blake case, it says no address given. And sure enough, I looked at those records up there, and the records this morning before court, and sure enough, there's no record anywhere of addresses in the lower court pleadings or anywhere, so obviously they can't send out a notice of the hearing. But now at least the court has this on the record because the forms are changed. And if you look on the record on these cases now that they're starting to come out, it has that record. It shows that it's been mailed out to the address, and if there's no address, they at least state it. So now, this is going to save work for the city attorney to file unnecessary motions to dismiss when people like, and I talked to Larry Sparks. I said, did you ever get notice of yours? And he said, no. I said, well, then how did you know to come to hearing? He said, I would just watching the computer. In my case, I never got notice of my first hearing, but I'm a guy that looks on the computer all the time to see.
You know,
so I'm trying to get help to this court.
I think you're admitting to unauthorized practice of law despite a couple of attempts.
Bruh. I think you're just fucking yourself over right now, son.
For me to advise you that maybe you don't want to, so all I can say is that...
No, I'm a law librarian, I'm a reporter, I'm reporting.
Oh, god damn it, now he's a goddamn reporter.
Silent, it sounds like to me.
No, I can report what's in the public record. And I'm also a member of the press.
Oh, a member of the press, too.
If you're going to stifle, if you're going to mischaracterize what I'm doing as a practice of law, and I think unjustly here, and I'm willing to take this one all the way up to the Supreme Court if necessary, U.S.
Spoiler alert, I think he actually does, and I have the case. I have the opinion. We can take a look at it after this.
Supreme Court, that is, where I've been docketed 4 times. That you are trying to stifle my freedom of speech, my freedom of press, and my freedom of assembly by being able to assemble with these people and look at their different things that are public records, to share notes, and there's a difference between legal advice.
So now he's trying to say that he, by him talking to these pro se litigants and giving them advice, it's infringing upon his right, his First Amendment right of assembly.
Advice and saying to someone, did you know you could do this procedure? Is that legal advice or administrative? As you know, that you are immune, have absolute immunity in your judicial acts. But if you do something wrong with your staff or something administratively or executively, you can be sued for that. You don't have immunity for that. I am acting as a law librarian, a grocery clerk, a member of the press, a member of the public that has the right to assemble, and I'm not giving legal advice. It's nothing different than what a law librarian will do. I just happen to have a little more knowledge than the average law librarian.
All right.
And I think you're mischaracterizing.
I understand your position.
If I may.
That's it.
Because you're about to throw me in, find me in contempt, it appears, from your demeanor.
Well, I want you to just go have a seat. I'm going to talk to you. Yeah. So I appreciate what you've said, but I'm ready to tell you what I want to do about the situation. All right. Now, Mr. Blandino, I swear to you, I do respect the freedom of the press.
Thank all of you for watching right now up to this point, all 417 of you.
A case where a guy named Sheldon Adelson wanted me to keep the press out of this courtroom because he was sitting in this witness box next to me for 3 days.
Yeah.
And I said, no, the press is here. And every one of those seats was full of reporters from all over the world watching Mr. Adelson testify right next to me for 3 days. There's a lady in Mesquite, I forget the name of that paper out there, Mesquite Citizen Journal, I think. You could check into that, but not that I have to justify this to you, but I protected her right to participate, be here in the courtroom, and she did a lot of stories concerning a case that the Virgin Valley Water District was involved in Mesquite. I've proven that, and that's what I do believe. I don't even have to tell you that, but I am. As far as freedom to assemble and be in our courtroom, I've said enough about that. I want you to come in. I want people to come into the courtroom, and I've actually, when this all started, frankly, I was glad to see you in the courtroom. I was, because I felt like you were, a litigant with misdemeanor appeals who was I felt like you were watching other cases to get a feel for me, so that when you presented your own case, you'd have some
Totally,
space,
yes.
So that's what I thought you were up to.
Yeah.
But here's what's happened. Over time, I do feel as though, and I know you disagree with this, but I feel as though on July 22nd, you attempted to represent a couple people that had...
Object again to that word represent.
That's my opinion.
Okay.
But at a minimum, even if you weren't representing the people, your activities interrupted, in my opinion, the judicial proceedings in a way that I felt was a disturbance that concerned me.
If that's true, then Steve
Here
Dempsey
today, you came in prior to court and you addressed my clerk on a couple of matters. You're not a lawyer, and in my view, that's very disturbing. I can't condone that, and I find that that's contempt of court. To come in as a non-lawyer, address a clerk of court regarding cases that are pending, and try to do something, even if it's procedural, to me that's concerning, and again adds to this idea of a problem.
May I speak to that, Your Honor?
Hold on, I'm talking. It's gotten to a point where I find I have the following duty to inform you. That all the facts I've talked to you about today, in my opinion, constitute contempt, which occurred in the immediate view and presence of the court, that's my court personnel, or me as a judge. Further, I find that you're guilty of contempt in this way.
Guilty of contempt.
I find I have to prescribe an appropriate punishment now for this contempt that I found. NRS 22.100 talks about the penalty for contempt. I can summarily punish this because it happened in the court's presence. I have afforded you some opportunity to talk with me in fairness, which I don't even think I have to do, given its direct contempt in this circumstance. And I appreciate our back and forth, and actually it's sort of influenced me, and I'm using it to come up with what I think is a fair way of handling what I see as ongoing and continuous contempt of my court. NRS 22.100 allows me to fine an individual who I find guilty of contempt, which I've done, an amount of $500, or I can imprison that person for a period of to not exceed 25 days in jail.
Up to
Now,
25 days in jail
for
for civil contempt.
Although I certainly could. What I'm going to do, however, is and this is not with any pleasure, I feel it's appropriate, but it's with internal reservation, because I don't like closing the courtroom doors to anybody. But I feel like the appropriate penalty for the contempt that's been ongoing, that I've described, that I know you disagree with, is I am going to ban your further presence from this courtroom.
That's accepted in my case when this hearing is a litigant.
You do have a case pending, and so I'm going to recuse myself from your individual misdemeanor appeal case, any of those matters that have come up. It'll be assigned to another judge.
So he's banned from the courtroom, and he is recusing himself from his current case and is being transferred to somebody else.
But because of your demonstrated course of conduct in disrupting the court, I find that it's a breach of peace, it's boisterous conduct, it's a violent disturbance in the presence of the court and its personnel, interrupting the due course of the trial or other judicial proceedings that I've had. And the appropriate, in my opinion, the appropriate punishment for that contempt is I'm going to ban you from further involvement in our courtroom or the area right outside the courtroom, meaning that I'm prohibiting you from further participating in that regard. So that means that if you come into the courtroom on any of these misdemeanor appeal occasions, or if it comes to my attention through court staff or anyone that you're right outside the courtroom talking with and dealing with people as you have done in the past, I'm going to consider that further contempt, and at that time I would be inclined to impose punishment that contempt law allows me to impose, including putting you in jail for up to 25 days.
So if he violates this judge's order or punishment, then he can throw him in jail.
So I want to tell you that I would view it as a violation of this order. If you were to come into court, even though you feel like you might have some kind of an excuse for doing that, you should expect to go to jail, because that's what I'm going to do.
Are you going to reduce this decision to writing?
I will.
Because I'm going to need specificity, specifically.
I will reduce it to writing.
The area outside the courtroom?
I will enter a written decision.
And I need to object, because for you to recuse off my misdemeanor case, it is not something that's sustainable in terms of your duty to follow through at a case to its conclusion. Okay. I had to go mandamus, if you want to take judicial notice, to get Judge Ritchie back on my family court case. They granted it.
I understand.
And if I go to the Madison Supreme Court, they will grant this too.
This has been something that I take actual sadness in. You're the first person, the only person I've ever said something along these lines to. You can either respect it or not.
I would ask you to reconsider that recusal, though.
That is the decision that I feel compelled to make. I've explained it. It's what it is. And so...
Is Helbert going to prepare the order, or are you going to prepare the order?
Have a good day. I'm going to write it myself. Have a good day.
Thank you.
So he does end up filing that writ, and now we get to see what happens in that case. And this will close out this evening for us. All right. I will get to the super chats after. So give me a second. I'll get to the super chats at the end. This is a pro se petition for a writ of prohibition and a writ of mandamus. Petitioner Kim Blandino argues that respondent Judge Bear improperly held him in contempt of court and banned him from the courtroom and from a 25-foot space outside the courtroom. Blandino further argues that Judge Bear improperly disqualified himself from Blandino's appeal from a judgment of a conviction involving a misdemeanor. Whether to consider a writ petition is within this court's jurisdiction, and a petitioner bears the burden of demonstrating that extraordinary relief is warranted. And they go through the applying case law. Yada, 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 da, 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 da. It's and basically saying that a writ, a prohibition, and mandamus is generally a very extreme filing to make. Like you have to show some level of extremity of prevailing need for us to take a look at this. Blandino argues that the district court exceeded its jurisdiction in imposing the courtroom and 25-foot bans because one of the incidents used to find him in contempt was not within Judge Bear's immediate view, and because Judge Bear did not immediately impose sanctions for the other two incidences. We conclude that that Blandino has not demonstrated that he is entitled to extraordinary relief. The district court's labeling the order as involving contempt and pursuing contempt sanctions pursuant to summary proceedings is problematic for the reasons identified by Blandino. See, providing that if the contemptuous act is not in immediate view, the court, an affidavit must be presented to the court of the facts constituting the contempt. Providing that if the court delays punishing direct contempt in the court's immediate presence until completion of the trial, due process requires contemptors' rights to notice and hearing be respective. The label of contempt and reliance upon NRS Chapter 22 is likewise awkward in this case because the district court imposed a sanction not available under NRS 22.1002, basically banning him from the courtroom. Nevertheless, Judge Bear properly acted within his inherent authority in imposing the bans to control the dignity of the courtroom and to prevent the abuse of the judicial process. C. NRS 1.210 Section 1, providing that the district court has the power to preserve and enforce order in its immediate presence. NRS 1.2102, providing that the district court has the power to enforce order in the proceedings before it. Halverson versus Hardcastle, providing that a court's inherent authority includes the power to preserve the integrity of the judicial process. Further, ordinary due process requirements were not triggered because there was no life, liberty, or property interest involved. Therefore, we conclude that the district court did not exceed its jurisdiction in imposing the bans. Blandino next argues that Judge Bear acted arbitrarily and capriciously in imposing the bans because he was not disruptive and was only trying to aid the court. An arbitrary or capricious exercise of discretion is one founded on prejudice or preference rather than on reason or contrary to the evidence or established rules of law. We conclude that Blandino has not demonstrated that he is entitled to extraordinary relief. Blandino has failed to demonstrate that Judge Bear acted with prejudice or preference or that his actions fell outside established law. The record supports Judge Bear's grave concern that Blandino may have been engaging in the unauthorized practice of law and that this caused a disruption to the orderly processes of the court. Finally, Blandino argues that Judge Bear exceeded his jurisdiction in disqualifying himself from Blandino's appeal, and Judge Bear should be compelled to decide Blandino's appeal. We conclude that Blandino has not demonstrated that he is entitled to extraordinary relief. First, this issue is moot, as the appeal has been decided by another judge during the pendency of these proceedings. More importantly, Judge Bear's decision to disqualify himself from future proceedings involving Blandino is not contrary to relevant authority. See NCJC Rule 2.11a, providing that a judge should disqualify himself, quote, in any proceeding in which the judge's impartiality might reasonably be questioned, end quote. Accordingly, we order the petition denied. Guys, that's not Kim Blandino. Settle down. So that's what it is. He failed, and he failed at his written mandamus. But at least he made do on his threat, unlike some people who decide that they're not going to make do on their threats to sue people. All right. Going through the super chats. Smarty Marty, $4.99. Happy Monday. Thank you very much. Philosopher King Gaming, $2. Can't wait for Edward Thomas Kennedy Saga. I've heard about him. I might have to put him on my list in the future. Andrew Rovers, $7.11. How are we supposed to take you serious when you're wearing that sweater, dude? Thanks, Andrew. Andrew, another $7.11. I was just joking. I know. Still annoying. But thank you for the super chats. Nathan Ardon, $5. Keep going. Colony L, thank you very much, Nathan. Colony L3, $1.99. I've been listening, so I haven't noticed it. I assumed the sweater. Thank you very much, Colony. Kit, $5. What's the fallout from all the judges being unable to judge on this? Does that mean it goes to federal or adjoining county? In certain circumstances, Kit, it can go to another county or another district. Depends on the rules of the prevailing jurisdiction. The issue, the thing is that a lot of these soft-sits do this as well, but a lot of other non-soft-sit litigants, vexatious litigants, try to pull this sort of trick where they feel that if they're able to get all the judges to recuse themselves or put them in a position to recuse themselves, then they'll get out of whatever bind that they're currently in. But that's not how that works. There's the old there's an old judicial maxim that if everybody's recused, then no one is. Right? So it's not gonna work. Ava Deacon, $5. This is what we call triangulation, often used by abusers, even in court. I assume that's referencing the his history and the family court proceedings. Amy, $5. Dang, this guy has a severe case of being a dingleberry. I agree. Sonia Garlic, thank you very much for the $7.11 super chat. Stacy Hansen, thank you for the $4.99 super chat. Artie, you look cute no matter what you wear, and the cats love you in any shirt. Ignore the haters. I'm more concerned that you sound sick. Oh, I'm fine. I'm not. If I sound sick, that's odd. I'm not sick. Promise. Tom Castro, $5. Wasn't this Blandino loser just on Law Talk with Mike's live stream? Yes, he was. Last Friday, I think Friday or Saturday, he was on there, and I was able to listen to that before tonight. Very interesting. Vanda, thank you for the sub. Deacon, thank you for the $5. So basically, all they think is needed to practice law is a suit and tie. Noted. Yeah, usually. Akira 808 State, $4.99. So they can practice law without a license. I say BS on that. I agree. Colony L3, $1.99. Can I hire you to sue Artie's corporate fiction? No. Tom Castro, $5. I'd love for P. Barnes to introduce this clown to Sparky. Yeah, he's not outwardly aggressive. He's just a vexatious litigant. You know what I mean? So, no Sparky, I would say. Pamela Gray, $10. Love your show. Red wine salute. Thank you very much, Pamela. Pamela Filon, $4.99 super chat. Happy holidays, Artie, and all watching. I would love to see you in action inside the courtroom, Artie. I'm sure you would kick butt. Thank you very much, Pamela. Kip 190, $2. He has a right to remain silent, but he didn't have the ability. He it's very clear that he never has the ability. Maggie Rose, thank you for the sub. Eric Facilier, thank you for the sub. Deacon for the $5. Another thing I've noticed that folks like this would not mind authoritarian rule as long as it favors them. Yeah, that's not. I actually agree. But yeah. Woodworker Don, thank you for the sub. Kit $195. Can you explain the contempt thing on the 25 days, like that Rick and Morty case where the judge went on to like 10 years due to interruptions? Well, the thing is, in Rick and Morty, it wouldn't be 10 years. In civil contempt, it would be 25 days. That's about right, because that's a civil proceeding, and you can only, and the burden of proof is very low. criminal contempt, my understanding, and I can be corrected, is that at the Supreme Court has said that the maximum allowable punishment for criminal contempt is a year. That's why I believe in Florida, the maximum criminal contempt is 364 days. In other states, I know that, I know in Michigan, for example, 93 days is the maximum for criminal contempt. But yeah, I believe SCOTUS has said that the maximum punishment for criminal contempt of court is a year. And thank you, Fred Kelsel, for subbing to the channel. Okay, so thank you guys very much for watching. But I need to make this a note. I am planning on. I think I mentioned this before, but I am planning on sending Christmas cards this year. And in addition to my family and close friends, I'm sending it to you guys, or at the very least, I'm sending it to those of you who are either tier 2 members, so sovereign members on my YouTube channel. You are subscribed on Twitch, and my Patreons. So those groups, I've actually taken pictures of myself with the cats. I'm currently editing it up, and I'm going to be needing addresses from you guys when you get a chance. Please send them to me on Discord. That's the best way of contacting me. So let me know there, or if you have my email address, you can send me an email. And I need to put this email address together quickly, so I can order the cards, and then I can send them out in an appropriate time frame. I doubt it at this point, but hopefully they might make it to you guys before Christmas Day. We'll see. But thank you very much, guys, for watching. Part 2 is going to happen when, I'm not sure, because this is going to be a pretty tough week at the office. Tomorrow there's not going to be any stream because I am going to be working on said Christmas cards and mailing lists and all that jazz. So, and more than likely Wednesday as well. Thursday or Friday, I will be finishing up Telling Lies, because I know that's hotly anticipated. It's either going to be Thursday or Friday. And then I'll try to have part 2 on whichever day that I don't do Telling Lies. So either Thursday or Friday, it'll be Telling Lies and or part 2 of Mr. Blandino. So take a look at that. Look for me there. Thank you guys again. I appreciate it. And I will see you guys next time. I'll be reminding people to send me their addresses in future streams and on the Discord as well. So we'll get through that as far as we can. But thank you guys again. Adios. Take care. Thanks for watching.